Good afternoon. My name is Ryan Foltz. I'm an attorney at Beresford Booth. My practice primarily involves construction litigation and real estate litigation. This will be my 25th year practicing law. I also, through the course of my practice, I do a lot of contract review and contract counseling, primarily related to litigation or some type of development projects. And today I'll be talking about some dispute resolution alternatives to litigation. Litigation follows a fairly traditional path, which starts with the filing of a lawsuit. Some investigation is involved. Obviously, before you bring suit, you have to develop facts, you have to determine what the claims are and those sorts of things. Once suit is filed, there are a couple phases that follows that, and the biggest, probably the most time-consuming and costly phase is discovery. And that's a process where parties exchange written discovery requests, produce documents, and also sit for depositions, which is testimony provided under oath. After that, you get into typically a motions practice phase where folks are challenging claims, asserting defenses, those sorts of things, which then leads to trial prep if it's not resolved, and then ultimately trial. And the problem with this model is that the dispute resolution mechanism, which typically is mediation, doesn't come into play until usually well after discovery, which at that point in time, you could be 50 to 70% through your litigation budget before you even get to an opportunity to sit down and try and settle a claim. Now, there's certainly benefits to litigation. Formal litigation provides a structured process which is bound by specific rules, specifically the rules of evidence and the civil rules. You also have a right to a jury trial as a matter of right. And more importantly, you have a right to appeal. So if you're in a trial court setting where you're not receiving what you think are appropriate or fair rulings, you can try that case to verdict, and then you can, after that, assert your right of appeal, which can go up to multiple levels to different appellate courts. The negative aspects of litigation are fairly obvious. It's expensive, it's certainly time-consuming, and it's definitely stressful for the participants that are involved in litigation. So 3 alternatives to active litigation. The first is fairly basic. It's simply sitting down and writing a demand letter, putting the opposing party on notice of what the claim is, and try to engage some type of negotiation with that party to come up with a reasonable solution. Another method of resolution is mediation, which is essentially a settlement conference, which is run by a mediator that places the parties in separate rooms, and the mediator will go back and forth and try and negotiate a claim or a resolution of a claim. And finally, arbitration, which is similar to litigation in that it's a formal setting. There are rules that apply to it, but it is not something that will be held in a court that's resolved by a judge or a jury. The simplest step, obviously, is sitting down, writing a letter, sending it to opposing counsel if there's an attorney or the opposing party. And the real key there is to put them on notice that there's an issue. Sometimes folks don't know that there's an issue or that there's actually a dispute that's out there, and they need to sit down and read the facts in the letter and the demands that are made in the letter. Most of my cases, in fact, start with a demand letter. We try to run this path first because usually, if you can get somebody to the table, have a reasonable, meaningful conversation, that's going to be the most inexpensive way to resolve the dispute. And sometimes folks want to resolve disputes without going to suit. The advantages are pretty obvious. It's inexpensive. It's quick if the parties are responsive, and the path is fairly flexible. You're not bound to file suit if the case doesn't resolve in this dialogue back and forth with the opposing party. The negative aspects is you really have limited leverage or negotiating power. You can't force anybody to do anything. If you have, for example, a neighbor dispute with a boundary line or an encroaching fence, you can't compel them to move the fence or do something to remedy the situation. The most frustrating negative of this course of action, obviously, is that you might just not get a response. Some people bury their head in the sand and just simply don't want to respond. Mediation is a very effective tool to resolve disputes. It provides a setting for folks to be heard, and it provides a setting for the parties to present their case fully. Mediators are very skilled at negotiating the resolution of claims, and most mediators are highly specialized in the area of law that they practice. So if you get the right mediator and you have the facts developed to an extent that the parties know what the claim is and can make a meaningful decision, typically a case has a very good chance of resolving at mediation. Some of the benefits: communication and evidence that's exchanged during mediation is confidential. There's a statute that governs the confidentiality of what happens during mediation. It also may be included in a contract as a condition before a party's able to file suit. And so for my practice, this comes up a lot in construction cases where there will be a specific paragraph that discusses the alternative dispute resolution process. Typically, it starts with a direct exchange. The second requirement typically is that the parties have to sit down and mediate before they're able to actually file suit. And that process is very productive, but there are times when you simply just can't resolve a dispute by attempting to negotiate resolution. Like I said before, most cases do resolve at mediation, so it's a very effective tool. Some of the negative consequences: it may be voluntary. You may not have a contract, or it may be a type of case where there is no mediation requirement. Even if you're in litigation, there are some jurisdictions that don't require mediation as an alternative dispute resolution method before trial, which is pretty odd, but there are other alternatives out there. As I discussed before, there may be limited discovery. So if there is a limit to the discovery exchanged by the parties, parties are less inclined to settle claims when they don't know all the facts, or they feel that they're not fully informed of the facts so that they can make a decision to resolve a claim. Lastly, there are no rulings or findings of fact made by the mediator. Some folks confuse a mediator with an arbitrator. A mediator simply is a third party, like I said, usually an attorney or a judge suited and experienced in the facts and the law that you're presenting to the mediator, but they're simply just trying to go between rooms to settle a claim. They'll present evidence, they'll shuttle information back and forth, but they're not there to make any type of ruling or judgment as to any claims or how the case should resolve. Arbitration is the most similar to litigation, but it's not conducted in a courtroom. So instead of having a judge rule on your motions or issue rulings related to the claims or potentially presentation of witnesses or evidence, you typically will only have a single arbitrator resolving all those issues. Depending on the size of the case, if it's complicated enough in terms of the claims, or if the amount in dispute is a significant amount, sometimes you can have a panel of arbitrators of up to 3 arbitrators. I've handled cases like that that typically involved multiple parties, in upwards of 15, 20 parties, and the amount in dispute usually was in the tens of millions of dollars. So there was a lot in dispute in those cases that required 3 different arbitrators who would hear all the facts and collectively make a ruling as a panel. Some of the benefits is that it should be less expensive than active litigation. Frankly, I've seen many arbitrations that aren't less than litigation and sometimes are more expensive than litigation. The other benefit is it should be an expedited path to recovery. It should be quicker than litigation. When you file suit, you typically get a case schedule that's going to tell you when your trial date is. In King County, that that timeline usually is about 18 months from filing suit. So even if you file suit, you're not going to get in front of a jury to present your case for at least a year and a half. Another benefit is the arbitration award can be reduced to a judgment. So even though it's a private setting that's not in court, the arbitration award can be reduced to a judgment, which is filed with the superior court. And that provides the party that prevailed the ability to execute on that judgment and take steps to enforce the judgment against the other party. Another benefit of arbitration is a lot of contracts, and like I said before, construction contracts very frequently require arbitration as the sole method of resolution. So if a contract has an arbitration clause, if one of the two parties triggers that clause by demanding arbitration, litigation is not a method of resolution. You have to go to arbitration to resolve your case. And in that situation, arbitration is typically binding. So in a contractual arbitration setting, whatever the arbitrator finds or rules is going to be what you're stuck with to resolve the case. Some of the negative consequences relate to the amount that may be recovered in arbitration. Even if a case is filed and you're in active litigation, there is a method for what's called mandatory arbitration, or what used to be called mandatory arbitration, where smaller litigated claims can be transferred into an arbitration process. There's a limit on what you can recover. The claim cannot be more than $100,000. But that setting is frankly a quicker means for litigated files to be transferred into an arbitration setting, because you typically get the arbitration heard within about 90 days or 180 days of transferring that file. Some of the consequences of arbitration is discovery is limited. It's not the same as an actively litigated case where you have a really broad power of subpoena to go get documents from third parties, or to issue subpoena to compel witnesses to provide testimony. Also, you have no right to a jury trial in an arbitration setting, which is significant for some folks depending on the nature of the claim. Finally, the right to appeal can be limited. As I said before, in binding arbitration, that arbitration will be the sole method of resolution. So if you get a bad ruling, you don't like the award that the arbitrator ultimately arrived at, you're stuck with it. You don't have any other remedies beyond what the arbitrator determined. The right to appeal is also limited. You may be stuck with the arbitrator's award. And even in cases that are proceeding through mandatory arbitration, the right to appeal, if you don't like the result, is simply an appeal to the superior court level. So if you file suit, your case gets transferred to mandatory arbitration, it's arbitrated, and you disagree with the ruling or the award, you can appeal to essentially the trial court, but there's no appeal that goes beyond that. I will say my personal preference, arbitration is not my preference. I found that it frankly sometimes is less effective than litigation and sometimes more expensive. So if I had the choice, I would proceed with a demand letter that may go to active litigation. We file suit and then try and point the case towards mediation, which, as I said earlier, is a very effective tool to resolve disputes. So I also want to let you know that we're a full service law firm. We have multiple practice groups beyond the litigation group and the real estate group. We have a family law group. We have a very robust business practice group and a trust and estates group. So if you have any questions or if there's facts that you want to run by the attorneys here, feel free to contact us, make an appointment, and we will have somebody ready to contact you and talk about your case with you. Thank you.